Hi, this is Peggy Clary of Clary Law Offices, and each day we offer a daily video, really short in time, on a topic pertaining to estate planning. And I'm really unsure if you're able to tell, but sometimes these videos happen at different locations, and tonight is after arriving after a late night meeting, and so shot literally from the front seat of my car. And it's late at night, but in a way I think that's a good stepping point for what we want to cover in tonight's video of a topic of a serious nature involving when your family enters into a divorce situation and your spouse is initiated dissolution proceedings from you, or maybe in some cases, a long-term separation. And it's important to remember in situations like that, why I'm going to show you why it feels kind of dark outside, why it may feel dark in your life, that planning for that event on the estate planning side and in the healthcare and living will directives is equally as important. Because under Florida law, your spouse, unless so otherwise planned around, is a default position for many decision-making choices and authority that, in normal circumstances you would want your spouse to have. But if you're in the middle of a dissolution, it's really important that you take time to look at the healthcare surrogate, your living will, your durable power of attorney, and you make sure, if you're not able to make your own legal or financial decisions, that you have someone else in a position of authority besides the spouse, who your family is in a huge state of reorganization. And the same is true for the will, because until you're actually divorced, Florida law gives spouses a significant number of automatic rights. And that's true whether you have been married for 20 years, 1 minute, or you're in the middle of a divorce but not actually have a court order dissolving your marriage. So a good tip if you're facing this life crisis is really to think about updating your will. And you can create a special type of trust called an elective share trust that says, in the event I'm married at the time of my death, and you have not yet gotten that decree of dissolution, this concept of the elective share trust can help insulate your assets, so these automatic spousal rights that would head over to your spouse are, if you want, distributed out in a very measured way, and it minimizes the amount of funds which they could normally take. Now, the elective share trust concept is very complex. Florida has a very broad law compared to other states of rights that pass to your spouse. So if you are in a dissolution of marriage situation and your decree has not been entered yet by the courts dissolving the marriage, we would really be honored to help you at Clary Law to walk you through this time and talk about your planning options. We hope you live your life with dignity, respect, and if we can help you at Clary Law, we're happy to do so. Thanks again for your time this evening, and truly hoping you don't have the darkness of a divorce enter into your life. But if you do, it's very important that you recognize the need to plan for that, and that there will be light at the end of the tunnel.